All right, hey everyone, Nicole and Alyssa here with Blondes Breaking Down Real Estate. We are continuing our series on buyer contingencies, and today we will be focusing on seller disclosures. To help us do so, we brought on real estate attorney Jonathan Black with Weston Law Group. We are super excited to have Jonathan on our episode today to give us some insight on seller disclosures and specifically what to watch out for, since many disputes are centered around them. So without further ado, welcome, Jonathan.
Thanks for having me. Thank you very much.
All right. Well, thanks so much for being on, Jonathan. Why don't you give us a little intro about who you are, what you do, just kind of a background.
Perfect. Well, my name is Jonathan Black, as you already said, and I have 3 children. But what I do for a living, besides watching my two-year-old and 3-year-old from time to time, is I'm the founder of Weston Law Group, PC. I'm coming up on a decade of practicing law. Before that, I was with Standard Pacific Homes, doing all kinds of different jobs. It was a home builder that was publicly traded. At one time, it was the 11th largest in the U.S. So I'm very familiar with ground up building, purchasing land, developing land, property sales, real estate agents, marketing, so on and so forth. And then from there, when I started my firm, I also took over a few different land funds, residential funds, and buying what started off as single family properties. And we moved the majority of them to multi-units right now. So that's a little bit about me on the real estate side. And I'm just glad to be here. So thanks for having me.
Nice. Well, before we get into some questions, we're sure you have plenty of crazy stories about mediations or real estate related lawsuits. We would love to hear a crazy one from you.
Yeah. So I was thinking about that, and there was this great one I had that was down in the Santa Monica, well, a little bit outside of Santa Monica, but it was dealing with Interstate 10. And my client had sold, my client was a semi-famous person. I won't go into details, but very animated and was known for his voice, a lot of voiceovers and voice work. And he had sold his property. Him and his wife are retiring. They're moving back. He was from Minnesota. They're moving back to Minnesota. And the person that brought the property eventually filed a demand for mediation. And then we were going towards arbitration before they finally gave up. But the craziest thing was the property backed in to, well, there's a house between it in the Interstate 10. And their complaint was that randomly at 4 a.m, some train on the other side of the freeway would blow its whistle. And it was a very faint whistle. My client didn't even know anything about it. Never heard it. Was a little bit older, so that wasn't shocking. And so there's this complaint that there's this train whistle beyond the freeway that this person could hear at 4 a.m. very faintly. And that was their big issue. It looked more like buyer's remorse to us, but it was a crazy, crazy scenario, and they took it a long way. We sat through mediation and started towards opening arbitration before I think they either ran out of money or their attorney, good common sense, took hold of their client and said, "You need to get out of this." So I just when I was first told the case, I couldn't stop laughing on the phone because my client had sent me the picture of where the freeway was and where the train was and where the house was, and I just couldn't stop laughing. So once I finally composed myself, I immediately accepted the offer to take on the case. And that was probably the craziest one I've seen so far.
And they let it go. So there was so your client won, essentially.
Yeah, my client won. We stood the test of time. But I don't know if my client won because my client inevitably had to pay me to defend
that's true.
claim. We could have gone after him for fees. Obviously, there's a prevailing clause in residential purchase agreements.
Totally.
So we could have done
that. Would have been another fight.
Yeah, my client just said, "Look, I feel blessed to get away from this person who clearly has lost their mind." So.
Well, that touches on exactly what we're talking about today. So during a traditional sale, there's certain disclosures a seller must fill out in entirety and send to the buyer. The seller is required to fill out these to the best of their knowledge for the duration of the time they own the property. These include the seller property questionnaire, the transfer disclosure statement. Can you just kind of explain what those are, what the seller's duty is? Also, for a buyer, it is a contingency. So if you see anything on there you don't like, the buyer can cancel and get their deposit back and move on.
Yeah, assuming the buyer hasn't removed those contingencies or been induced to remove those contingencies by a fraudulent representation of the seller, which could be a claim that would go past the contingency period if it came out between
That makes sense because
removal of the
fraud has no
contingency.
statute of limitations.
Yeah, well, and the close of escrow if you're in that period, right? So, when I looked at the TDS is based on Civil Code 1102, right? So invariably it talks about disclosures. Now, the one thing that's important on that is that it's not a warranty being made by the seller. So inevitably people point to it that this is a warranty. And I think the confusion there is because in the TDS, it does say that the buyer has an ability to rely on the TDS for the information being provided and making their decisions. And people get confused with that reliance being a warranty. It's not.
Right.
So I think that's one thing that's important when you're looking at the TDS to understand is that those representations being made are important for a variety of different reasons for that potential buyer, especially if it's a first-time buyer.
Mm-hmm.
Now, if you look through it and you go through the sections, Section A is a list of what the property has. So, if there's some kind of confusion, someone checks hot tub and it doesn't have a hot tub, it's going to be a little bit of a problem. Now, obviously there should be other things going into that where that's corrected before contingencies are left. There's the avid that you guys do, and that the seller's agent would do. So, that would probably correct something like that. Then Section B is a disclosure of defect on the property in which you would need to disclose if you were a seller. So there's an opening there for the seller to bring forth disclosures that would be important, such as a train whistle. Or maybe actually the freeway was on there. The train whistle was not on that case.
But it's subjective. So if it wasn't,
right.
It's subjective, right? Because it states on the disclosures like a nuisance. And if the previous owner didn't notice it, then it wasn't a nuisance for them, correct?
Well, they notice everybody notices a freeway that close.
Right.
Or if there's airplanes or something like that, a noise, a nuisance noise, people will notice that. Sometimes you see those flight patterns also in the general disclosures too, right? So, if you notice it, you should be aware of making that disclosure. But they never noticed the train whistle. They lived there for like 20 years, never noticed it. Yeah. So, but they did put down the freeway. So, yeah. There's another one where it was a new home buyer that had sold my client a property, and the train went by at 4:00 in the morning. And there was no freeway in between on this case.
So it's right there.
Yeah. And, my clients fell in love. Him and his wife fell in love with this property, and it went by the first night they moved in. It went by and woke them up.
Oh, no.
And they were just at a loss, right? So now, look, they said, look, we had to drive over the train tracks to get into the community. We had to drive over the train tracks to leave the community. So we knew there was a train there. Yeah. We just didn't know the time in which the train went by. Now, the builder predominantly may not have known that either, right? Because we're talking about a time late at night when a builder wouldn't necessarily be out there building or selling or showing property. So, there's a good argument to defend that non-disclosure. I don't think it's very valid. The better argument probably would be the fact that you had to drive over the train tracks to get in and out of development. So, I think these things are important when you're looking at the TDS, like obviously there's some things there that open up and give some light to your guys' job, right? It mentions the avid in there and having that attached to the TDS, which I think is important because, as real estate agents, you guys hold a higher position to a buyer, especially a brand new buyer, right? They're almost, the relationship there is almost like teacher-student to an extent. And they're counting on your experience in understanding the transaction, understanding the documents, and understanding what you're looking at in a property, understanding values to help them make an offer that makes sense. Even to an extent, they rely on you for some information on loans and how that works and the escrow process and what inspectors to get. They haven't dealt with inspectors. You guys have. So they're really heavily reliant on you guys, and that form kind of follows that the same way. Now, they obviously need to apply their own common sense and do their own due diligence, but you guys are there to guide them through that. And real estate agents are very, very important in this process. Now, you have to be careful, though, because that reliance sometimes leads to to asking you legal questions or potential lender questions or potential general contractor questions, which is outside of
Totally.
your realm.
Mhm.
But there's a lot you can do up until that threshold where it crosses to help them with the transaction, which they're so unfamiliar with. And it's so important for you guys, especially right now, when people, this is the biggest purchase of their life, a home, generally for most people. Some people that may be different, but they're really
So
invested. And it's an emotional, even though it's a contractual thing, one of the most commonly questions I get on this failure to disclose is, it's caused me emotional distress. Can I sue for that? No,
yeah, how much money is that worth?
Right,
$1 million.
right. I have $10,000 in damages, but I have $1 million in emotional suffering.
Right.
Well, I think the point you just made about contractors and lenders and, a lawyer, I think it's really important if you're a buyer watching this, you want to work with an agent like Alyssa or I that has a team behind us that, like Jonathan here, if you have a legal question, we say, you know what, that's not our area of expertise. Talk to Jonathan, or a lender or a contractor that's a phone call away. That's, even if we may know the answer to that question, we want you to hear it from that professional so that you really know and trust us that we're giving you that professional advice from the actual professional in that area.
Right. And that's an important point. Like, I work with real estate agents and brokers all the time in regards to their clients. And so, one of the things is the real estate agent, and inevitably in your case, your guys' case, you have the inside track and knowledge of what's transpiring in the transaction, what the agent's telling you from the other side, or maybe if they're representing themselves, what they're telling you. And it allows us to step in a situation that may be starting to go sideways or causing aggravation or potential breach situations, and just help move that in the direction it needs to go. Right. So you guys play a highly important role in that. For a lot of different reasons. So it's really important that your real estate agent, like you just said, has surrounded themselves with professionals like you guys have that understand the market and the selling of properties, and the people to refer out when you hit those issues with the transaction. Highly, highly important.
I think you hit it absolutely on the head. And one thing that I did last night was we went through the seller disclosures. And I think that one thing that's important for buyers to know is they have to read in between the lines, right? The seller doesn't always come flat out and say something, but they might say, they might allude to a repair that was done. And that's an indication that we need to dig deeper and not just expect them to like lay it all out for us on a silver platter. So it's asking all those detailed follow-up questions, getting those in writing. Would that help a buyer in the case of non-disclosure?
It would absolutely help a buyer. Like you guys had brought a potential question regarding deaths on the property, right? And so there's a weird rule there and how that applies. So if you look at that, that's under Civil Code of Procedure, I think 1710.2, if memory serves me correct. And
we're not going to fact check this. Don't worry.
Twitter fact check.
Right.
But it's there, right? And so there's some weird loopholes. So if it's beyond 3 years, right? The person died over 3 years ago, then the disclosure wouldn't be necessary as it applies to, I believe it's on the, I want to say it's on the SPQ form, not the TDS, but the SPQ form actually outlines boxes to check, and that's one of them. It wouldn't be necessary there. But if you were asked directly and you had knowledge of the death on the property and you didn't disclose it, that could be a potential issue, right? So it doesn't mean you need to make that initial disclosure, but if there's some more diligence done there by the agent, potentially something like that would come out, right?
So let me ask you,
100%.
if it was natural causes versus, say, someone was murdered on the property, what are the rules with that? How does that need to be disclosed? Does it need to be disclosed?
I would disclose that there was a death on the property in the 3 years. It does need to be disclosed. Now, there is a loophole if you're looking at that code section. If it's an HIV or AIDS related death, that's something that would not need to be disclosed. For some reason, that has been carved out under Section B. So I believe the quote is that an occupant of the property was living with HIV or died from AIDS related complications, and that would not need to be disclosed. So there is a little loophole there. I think that goes along with patient privacy.
Okay.
if the patient's bill of rights, which, HIPAA, which we take very seriously in California. So I think that's why that's there. I didn't look into the legislative intent on that, but
Okay. So from your experience, if say, I was buying Alyssa's house and somebody was murdered there 6 years ago and she did not disclose that, and I buy the property and then, I'm living there and I start getting, haunted or something like that.
right.
And, the neighbor says, oh yeah, so-and-so was murdered there. You didn't know that? Is that anything that someone could come back and say, well, that was something that needed to be disclosed, or is it just that 3-year mark? Do you know? I know I've watched a
So
lot of.
that's a great question, because there's a lot of clients that have a problem with deaths on the property, right? There's a lot of superstitious people, and that's a huge issue to them. And it causes them a lot of disturbance, and it can affect the sale of the property, right? Because it potentially could single out buyer pool. So the resale of the property could potentially be an issue. The 3-year statute is there so that if it happened in 3 years, they'd have to put it on the SPQ form and send it over.
Okay.
If the agent asks directly to the buyer's agent, or excuse me, the seller's agent, has there been deaths beyond the 3 years or additional deaths, a non-disclosure of that comes out later that causes problems potentially could be something problematic. Now, again, the trick to that would need to be in writing. It would have to be a very direct question. It's something that's a little bit beyond. I would be careful, because you're opening a can of worms here. It's almost fishing for reasons not to buy a property, but
if we know that's a hot button for a buyer and we've had that discussion, then that might be a pointed question to ask.
yeah, if that's something the buyer brought up to you, that the last place was haunted,
or that they're super superstitious and
right. And I try to stay away from those conversations, because sometimes it's hard when people are saying things to keep a straight face. That's not a knock against anybody or anything. Sometimes you hear these stories and you're just like, really? Like that's how we came to this? Okay. But yeah, look, inevitably your job is to assist them in making a great decision, and if that's part of the decision making protocol, then that's how you have to do.
That's that pointed question.
Push on that issue.
So everything that all the, I guess, issues that I've had with buyers who have closed after properties have all kind of fallen under non-disclosure, because it's such a loose area. Kind of explain what happens if we have pretty sure evidence that a seller didn't disclose something. Does the buyer have recourse to go after the seller? What does that process look like?
Well, first off, it just depends, right? So there is a carve out, 1102, I believe. 1102.2 is a carve out. So you got to look at who the seller is, right? And so that can affect the course of the transaction and disclosures. So that would be the first step in looking at that. So if you have, for example, if it's a sale by court order, a probate issue,
right.
Generally a trustee or fiduciary doing a sale, unless the fiduciary lived there. So if it was, let's say, your mom's trust, but you lived at home with mom, you're going to have to make the disclosures. Now, if you didn't, you lived on the other side of the country for the last year, and mom dies, unfortunately, and you're selling the property, then there's an exception here. So you want to be sure on the exception, partners, percentage interest, things like that would spring this exception. And it's listed there. If you look at it, I believe it's about 8 or 9 different reasons. It's not too hard to understand, but it's there, right? Co-owners, divorce, husband, wife transaction. Those would all not have the disclosures in it. So, but if they do need to make the disclosures and they don't do it, and they're aware, they known or should have known, right? Generally is how you're looking at it. They can say, I didn't know all they want, but the test is like, if you're walking by, or it's 100 degrees last summer, you put on the air and it didn't work. You called the service man, he came out and said it's going to cost us to fix, and you decided not to. And then you go, I didn't know. Well, it's not going to hold, So inevitably, if that happens, the first thing that would happen would be a demand for mediation, unless the parties can come to an agreement, right? So if the parties can come to an agreement that, the seller pays for whatever it is to be fixed. Now, generally, if I'm representing a seller, or you guys are representing a seller, I'm encouraging them to make a payment, not to hire a contractor, right? Because potentially that contractor screws up and liability doesn't end. It continues to circle, right? The contractor came out and screwed it up. So everybody, I would say, get 3 quotes, and we're going
let
to
them go with,
we're giving you the average of that in cash. You can hire someone, not hire someone, do whatever you want, but we're out of this, right? So, and then I'd get a 1542 waiver because I'm not looking to come back ever again, right? One and done type scenario, and it happens. It definitely does. But let's assume that that isn't going to work out that way, and you represented the buyer. The buyer would then need to do a demand for mediation. And if they go to mediation, hopefully they can work that out. If I went to mediation, again, I'd make sure my buyer had bids on fixing the issue so we knew what the damages were. And if there were any other issues, now's the time, right? Because you're going to have a full and final settlement. So let's flush that all out in this mediation. If we're not successful in mediation, then it's off to arbitration. Now, the issue here is this is a very big gamble inevitably for people that end up in arbitration with an arbitration decision, because these contracts that provide for the same reason that you're in mediation and arbitration also provide for the prevailing party to get their attorney fees and the cost of arbitration, right? Which I can tell you on a $10,000 dispute, you could potentially be looking at, $70,000 to $100,000 for the losing party to have to pay the winning party, right? So you got to be very careful here in how you go about this. So if you can come to terms in mediation, even if it's not perfect for you, it's not a home run, that's what a settlement is, right? And you're not happy, but you're not miserable. You're just in an average medium, right? So if you can come to that, that's great. If not, then you're off to arbitration. Now, if the seller never comes out, right, and says, doesn't respond to mediation and doesn't respond to arbitration, which would be a mistake, right? Because you want to be able to yield that prevailing party fee, and inevitably, if you guys aren't able to work it out, then you could file for in court to push the matter of arbitration or potential default and get a judgment against the person in that regard as kind of a last effort. You see a lot of filings on courts for specific performance when someone's trying to back out early, but they're not waiving the mediation arbitration by that filing. They're putting that in there, but they're doing it out of abundance of caution. So you need to take the proper steps. And if you're on either side, to decline mediation or arbitration is a huge, huge mistake if you've initialed those sections. So that's how the disclosure process generally works when there's a failure to disclose and you have a buyer that's been substantially harmed.
So
and you have to, go ahead.
No. Go ahead and finish that. I'll interrupt after.
You have to look at the substantially harmed issue, right? So if we're talking about $1,000 worth of damage or something under 10,000, there's also a carve out in the residential purchase agreement for issues that are under, within the jurisdiction of small claims. So they could skip the
That was my next question.
Oh, sorry.
No, I'm so glad you're touching on that, because that's what has been brought up, is that we can kind of skip some of that and go straight to small claims if it's under 10,000.
Right, and you can. So there's a carve out. It's C under that section, that if it's in the jurisdiction of small claims, you can file there. If you get an appeal in small claims, and under the appeal, you can have an attorney represent you if necessary, right? Again, you're capped at 10,000, so it's very difficult for attorneys to come in and do stuff like that, but we can.
But I mean, a lot of our disputes usually fall 10,000 or less. There's very few that are above that. So at least a buyer feels that they're not going to be faced with, come out of pocket $8,000 for a repair or spend $70,000 with an attorney. There is kind of a middle ground there.
Yeah, and a lot of it's just balancing and being fair. Like, inevitably, if I have someone, one of your clients come to me and I can't, my cost versus what they're going to collect just doesn't make sense. I think it's a responsibility of the attorney to tell them that, right? Just like in a transaction, you have a buyer that's going to make a very bad decision, refer them obviously to a real estate attorney, but also put in writing, your thoughts to them, because there's a lot of emotion in this scenario, right? And you guys are good at handling that. I wish I was better. Definitely, I either laugh or I try to understand where they're coming from. But my idea is trying to find out the legal issues and the implications and how to help them on that. And the emotional part is kind of filler for me. But it's something that you guys work beautifully off of, and real estate agents really have done a great job, being able to balance emotions in these transactions, because home is where the heart is. I mean, you see all these slogans out there.
Totally.
It's tough sometimes.
So I want to circle back a little bit to kind of what we were talking about in regards to some sellers not having all of the prior knowledge about the history or the condition of the property. And Alyssa talked about needing to do the extra digging, and how some of the things that are on the TDS or the SBQ may hint at something that you need to further investigate. So, clients or sellers rather that are either older or have passed away, or the property's bank owned, or it was a flipper and they don't know the prior knowledge, or there was maybe a tenant occupied property for a long time. A lot of times you'll see on the listing, it'll say, seller has limited knowledge of the property's condition, or, repairs and such. So I'd say let's kind of go over some of the advice that we would give, if there was a tenant occupied property and, there was a property management company that was running it for a while. We'd want to get, their logs of all of the repairs that were made, and if there were any insurance claims or anything like that, so that you really know exactly what's going on. But is there any other advice that you would give for, these properties that have limited knowledge?
Exempt, yeah.
That is a great question. So I'll start with the tenant, and I'll work through a variety of other examples, and interrupt me as need be. But the tenant, as an owner, you have a move-in inspection, you have a move-out inspection under 1950.4, right, that you're going to have to do. So there's going to be a log. It looks a lot like your Avid to an extent, and a lot like the SPQ, a checklist, right? And a lot of those forms are there from the apartment association and everything else. Those should be there. If someone's getting an occupied property, you want to get an estoppel certificate to find out what contract's there and what can be done. And remember that there's now under 1482, there's now rent control. It doesn't affect single family, but if you're buying a condo or something else, you might want to consult a California licensed real estate attorney in regards to what that looks like and you getting possession back, if it's possible, right? So, there should be records there. It does not absolve the seller from filling out these forms. They can say, I have limited knowledge, but if it's something that they should reasonably know, or it's something their property manager knows and they don't disclose it, it's going to be problematic, right? Property managers don't like subpoenas. So inevitably what they do is they give you a whole file. Boom, here you go. That answers all your questions. And in that's going to be correspondence with the tenant and property manager. And that generally is something that's an agent of the owner, and the owner is the seller. So if that seller doesn't disclose that stuff, doesn't review that stuff, doesn't take their time doing that due diligence, they're going to be potentially liable to your buyer in that regard. So a tenant occupied property, I know everybody likes to say this isn't an issue, or I have limited knowledge, so I'm not responsible. It doesn't work that way, not in the eyes of the law. So I would
Very good to know.
Very careful in taking that position. Now, as far as someone that's elderly, if they have dementia, you have a whole nother list of problems, right? They can't contract. So inevitably there's a conservator there. If there's a conservator there, then 1102.2 would apply, and the disclosures are going to be none. It would be that they don't have to make the same disclosures as a normal seller would, right? So they're going to be a carve out from your TDS and your SPQ. So you got to look out for that, unless the conservator has been living there over the last year, right? The fiduciary. So if they've been living with them, taking care of them, then they're going to still have to make those disclosures. So, but they're not going to be able to contract the sale of the property anyway. So you're going to be dealing with that person.
What about flippers? I feel like flippers come up a lot because they like to say that they never lived in the property, but it's like, but you just spent 3 months renovating the property. How do you have no knowledge about it?
And on that, should they be responsible for providing the TDS and SBQ from when they purchased it? If it was 6 months ago, they flip it, should they be responsible for keeping those documents, or is that a totally separate thing?
If I was them, I would probably do that to err on the side of caution. If they have those forms and they have it in the file of the property, it just depends on how professional they are or not in what they're doing, right? And everybody, if they're keeping good records, they should have that. They should also have an issue, all the permits pulled, all the construction done. The property should have a lot of information with it that they're disclosing that should make someone feel better. Will it catch if there's a train on the other side of the 10? Probably not, right? So, it's one of these things where there's going to be some knowledge and some things that are going to have to be investigated by your buyer, right? They're going to have to use some common sense, some expertise from you guys, and inevitably inspectors, and look at it for themselves. But yeah, it doesn't absolve them either. You know, I always get that people that flip property, and then, well, I fall under, you know, it was bought by the bank, sold at the steps, I got it, they didn't disclose anything. Well, yeah, the bank's fine. They're not in any issue. They're an exception to that carve out under 1102. You're not, though, right? You bought it once you laid your hands on it and took ownership of it and started doing work on it, and you're not in the capacity of a carve out for someone that has to make those disclosures. You're responsible to make those disclosures. And so you need to do it, right? Generally speaking, you know, it just depends on the person flipping the property. So I would be careful because, you know, owners can pull permits just like general contractors can. So is the person doing the flip a general contractor, or is it the owner of the property, right? So those are nuances that you might want to look at and have an inspector or a GC look at. And I know you guys have people like that on your team. So, you know,
and I think the big takeaway is question, like ask more questions.
Yeah. In writing too, right?
Yeah.
You want it in writing, because the worst thing is the he said, she said.
Oh yeah.
Like I asked them that, and then he goes, no, you didn't, you know, like, come on.
100%.
Prove it.
And you see that a lot. You know, it's funny though, in your guys' in civil cases for real estate agents versus, you know, dealing with businesses. Businesses are a lot of emails, no forms, just emails, right? And then you guys have all these forms, and then it's not so much emails, but text message logs, right? Agents are always texting, and that's okay too. It's in writing, right? That's a right.
So text message is admissible in court for agents.
It is, yes.
Great to know.
Right. So yeah, just be careful what you're putting through that text message log. Things that have come out in discovery, which were a little bit questionable, that agents probably shouldn't have been saying to each other, especially married people.
Totally.
So just be careful, because some of that stuff does come out, you know. So, you know, and then there's other things that people are using. I think there's other apps out there in which you got to be careful of too, like, because you can delete the text message. So make sure you're just using normal text message that's connected to a phone number, because it's discoverable on phone logs and so on and so forth.
Got it.
So
that's great advice.
So let's just touch on really quickly, just so that everyone has a really clear idea of what's in the SBQ and what's in the TDS. What should they expect to see? Go through the list, please, of just what the main sections of those two documents are that a buyer should be expecting to read through.
Perfect. The TDS is the one that creates the reliance that a buyer can rely on it. It also has an opening for disclosures to be made regarding, it's not a checklist, right? That's the SBQ. An SBQ goes through a checklist of sections, but the TDS has that, it has the AVID, and it has the health and safety codes regarding smoke detectors and water heaters, which is always something that, you know, if there isn't a strap around the water heater, we generally have a problem here, right? So, you know, that's the TDS in that regard. It kind of sets up some things. The SBQ is more of a checklist, right? So it'll start running through things such as the death and other components that are important in regards to determining whether or not the property is something that one would buy. So, you know, the first one obviously is the seller awareness section in regards to the SBQ that talks about certain things that the seller might be aware of. And it's a very specific checklist of questioning. So when I look at that, it reminds me a lot of like form interrogatories that the judicial counsel wrote for us when we're discovering information from another party, when we're making a request. It's almost the same thing for your business, right? So it's that form that's going through a list of every question that potentially would be there. You know, you got structural, disaster relief, mold, water, pets, repairs and alterations. So the person doing a flip there would probably have an attachment to that, right? Because they've done a lot of repairs and alterations, which are important. Landscaping, whether it's a condominium, liens on the title, issues with title. Sometimes you have some weird things there, right? So I'll give you an example. If I have a property that I'm renting and that potential tenant has signed a lease option to buy, but hasn't recorded it, although those can be recorded and show up on a prelim. Potentially there's one floating around out there. And now because I bought, because you're representing a buyer and the buyer buys it, potentially they run into that problem where there's issue with, specific performance, them wanting that property, the previous owner, and that new buyers can get sucked in, and potentially you guys too, right? Inevitably. So, you want to be careful, and so that's really what the SPQ does, is it really breaks that down into what I would call like a set of form interrogatories for our business. It's kind of the same set of form interrogatories for you guys. But it does have a great quote on it. And, we were talking about this earlier, but it does say seller's disclosures are not a substitute for your own investigation, personal judgments, or common sense. And I just love that quote. Every now and then I see these quotes from Carr, and it brings me great joy to see them say things like that, common sense, which isn't that common, as we find out. But it isn't. It doesn't replace your investigation as a buyer. As a buyer, you have a responsibility to do your own due diligence in the property you're buying. So to sit back and rely 100% on the seller is a huge mistake. And I'm sure you guys have had that conversation multiple times with your clients about what due diligence means and what they should be looking at. It's not just what the color of the countertops are or what appliances are in the property. It's also, other things that involve the property, right? Is there an HOA, right? If there's an HOA, what is that going to cost you? Is there a lawsuit pending with the HOA that potentially could affect your property and change your fees, right? Was it occupied by a tenant who potentially was running a meth lab, right? These are things that you need to know. And you'd be surprised if you just Google a property address, what you can find out about a property. Mm-hmm. Or if you look at a property detail report, who's owned a property. It does bring me to one funny disclosure story. I'll tell you real quickly. I was dealing with a client, a very, very wealthy client, they were renting a property they were going to buy for $30,000 a month. They're renting this property in LA. Yeah. So they're going to buy it. And I think it was like $14 million or something, because their property had burnt down. And inevitably he brings me the deed. And in the deed, there's deed restrictions that we haven't seen for a long time. But the original deed was back in 1956 when the land was split. And those deed restrictions had some very, let's just put it, non-constitutional
yeah, I've seen them.
Yeah. So he asked me, he's like, is this valid? I said, of course it's not valid. But it's still there. He's like, whoa, can't it just be gone from my deed? No, the deed runs with the land. It's always going to be there. He's like, do you think it'll affect my resale? I said, well, it's going to be given to any seller. And potentially maybe the seller gets pissed off. Potentially they look at it as how historically stupid some people can be, including certain banks. So, I always kind of admire, what you will and will not find in your own investigation. That's something he found in his own investigation, which had impressed me, because generally speaking, he didn't do a lot of due diligence. He had a lot of people doing due diligence for him, but he had found this. So, yeah, it's very interesting. So, when you're looking at disclosures and what's being made, I would obviously have a conversation. If you guys were my agent, I'd be talking to you guys and saying, tell me what your thoughts are on disclosure. Okay, great. Should I get a GC to look at this? Who should I get? Right. And once
totally.
Maybe you're making a recommendation on that, and then I say, okay, great. Do you have someone for me? Right. And if there is a restriction or an easement or something like that pops up in the disclosures, maybe that's a question for the attorney, right? Because easements do pop up, utility easements, other things will pop up that potentially cause someone who's not very familiar with the archaic way that land was done. And this is archaic. This comes from Joe.
Yeah.
When you're talking about
the southwesterly corner of the northerly region.
Yeah, grant deeds, writs of execution. That's an eviction term, but that comes from England. I mean, these things are very archaic, and they're meant. I'll give you a little secret here. They're meant to confuse you, so they keep people like myself employed.
Well, they're working.
They're so archaic in nature, but. Look, I rely heavily on, if you're a buyer, you need to rely heavily on the advice of your agent. You need to take that into the disclosures, and whatever your agent's suggesting to you, I would potentially look at doing, right? If they're suggesting that you get certain types of inspections, talk to a GC, talk to an attorney, I would take those steps, right? Because this is a very valuable asset that you're purchasing. So,
and I think you,
oh, go ahead.
Oh, I think you hit it on the head. So basically, this is just one. So the seller disclosures is one portion of their inspection period. We can think of the inspection period kind of like the discovery period if you're getting ready for a case. We need to kind of piece everything together and get the full picture, and then be sure to ask as much documented, specific questions that pertain to the information that we discovered. Would that be a good way to sum up the advice for a buyer?
That would be a fantastic way. I probably should have written that down. Luckily, we're moving. I can steal that later.
Yes,
of course.
I'll give you a quote. But yeah, no, that's exactly right. I couldn't have said it better.
Awesome.
Perfect. Do you have any other questions, Alyssa?
I think that sums it up for me. I think that was a great conversation, and I learned so much about this, and I will be better able to advise my clients moving forward. So thank you.
Ditto.
Perfect. Thank you guys for having me. And if your clients ever have any questions, by all means, like, I would love to answer them. And
Absolutely. We will have Jonathan's email attached below in the episode notes. So please make sure you check those out. Thank you, Jonathan. We're so appreciative of all the advice and information you've given us today. For everybody watching, please do not forget to like this video and subscribe to our channel. We're going to be continuing on with our series here soon. We've got a few more videos coming up on buyer contingencies, and then we'll be sending it over to some advice for sellers. So we look forward to seeing you soon. Thanks,
perfect.
everybody.
Can't wait to be back. Thanks, guys.